Hi, good morning, good afternoon, everyone. Welcome. My name is Sang Kim. I'm a senior counsel here at Visa Nation, joined by managing partner Shilpa Malik. We're here to talk about H-1B alternatives. If you are here on this presentation and webinar, we hope that your H-1B efforts have been, fruitful. But if you are here, we are likely looking at considerations towards what options may be available to you now that the H-1B initial lottery has been completed. There may be more lotteries later this year, but our presentation today will talk about possible case types and strategies that we have conversed with our clients based on your background and options. I also want to start off by reminding and explaining everyone to please that we welcome your questions depending on how you are viewing this webinar, whether on LinkedIn or YouTube or elsewhere. We do ask that you not share any personal or privileged information. We will not be doing a full consultation at the end for a question and answers. We'll try to keep the responses generalized and applicable as much as possible, but we will not be discussing any fact-specific strategies or questions. We in turn invite you to contact our team through our website to book a consultation or to just contact our team for what services we can render. Shilpa, would you like to just say anything before we begin our presentation today?
Yes, hi everyone. It's exciting to discuss various options with you all. Thanks covered a lot of the housekeeping items. I just want to add that what we are about to say is not something where you can say one size fits all. It depends on every individual's circumstances and an employer flexibility as well as employer support where required. So while there may be some options that may be available to you, there are a lot of other factors that go into determining whether or not that particular option would actually succeed in your case. So please take this with an open mind. And again, if you believe that there's a certain classification or visa category that may actually apply in your scenario, as Sang mentioned, please reach out to our office for a more detailed consultation so that we can review your personal data one-on-one and tell you that yes, that is a good choice for you or not. So that's all I wanted to add, Sang. So you can take it further from here.
Great, thank you, Shilpa. So let's start off with what we'll be covering today. First, we've organized our presentation to first discuss about employer sponsor strategies. Simply put, this is if you have an interested employer, likely if you were a registered, you have an employer who was willing and able to sponsor you for an H-1B if you were selected for the lottery. If the employer is still available and interested, there might be some strategies that could be eligible or available under the circumstances. Second, we'll move into what we coin or others coin as self-sponsored individual strategies. These are case type strategies where you don't necessarily need a job offer. You may need a business entity, but that business entity may be something you could create on your own. Then we turn to the green card immigrant visa strategies. We cover these mostly because one, we assume most of those pursuing U.S. immigration employment options will eventually want to transition to a full legal permanent resident. Also, although most of our clients and your peers are transitioning first to a visa type to enter the U.S. To facilitate living, working, and traveling while you pursue a green card, depending on your background, especially for those who were born in a country where you're not suffering through a long backlog, it might actually be just as advantageous to pursue the green card option instead of the visa strategy or in addition to the visa strategy. And then we'll conclude with some general timing and planning considerations before we move into the more general Q&A session. So with that, I asked Shilpa if you wouldn't mind beginning our conversation with the CAP exempt H-1B information as well as the L-1 visa.
Yeah, hi. Good afternoon, everyone. Again, the two things I'm going to talk about is the possibility of pursuing a CAP exempt H-1B or an L-1 where it's possible. A CAP exempt H-1B essentially relates to an employer who is considered CAP exempt. Now, which are the employers that are CAP exempt? nonprofit research organizations, institutes of higher education like a public university or a nonprofit private university, which offers a degree higher than past the high school. So it could offer associate's, bachelor's, and master's degrees. So if you have a job offer from a university, then you could take that. Now, there's obviously a third category as well, where a private employer may have an affiliation with a nonprofit research organization or with an institute of higher education to perform services on their behalf, in which case the private employer could technically apply for a cap exempt H-1B for you, piggybacking on the cap exemption that is accorded to the higher institution or to the nonprofit research organization. So that's what a cap exempt H-1B is all about. Now, the beauty of a cap exempt H-1B is that if you do end up getting a cap exempt H-1B sponsorship for a position with any of these entities, you could technically work for a private entity concurrently if the private entity was willing to file what's called a concurrent H-1B for you while you maintain cap exempt H-1B status with a nonprofit research organization or institute of higher education. So you do have that option. Again, it all depends on you actually receiving a qualifying job offer and the entity that's sponsoring you being a H-1B cap exempt employer. So that's a little bit about the cap exempt H-1B. Now, what are the advantages and disadvantages? The advantage is essentially that it can be filed at any time during the year. It does not go through any lottery or a quota. So it's open-ended. The disadvantage is that then you're sort of stuck to work with a cap exempt employer until the time you go through the lottery again and happen to get selected in the lottery, in which case you'll be able to switch full-time to a private employer who's not cap exempt. So you cannot do away with the lottery requirement by going on a cap exempt H-1B if in the future you ever decide to work for a for-profit employer who does not have any of these affiliations that we previously spoke about. So that's my sort of advice on cap exempt H-1Bs. Now, moving on to an L-1, it may not apply for all of you as previously mentioned. An L-1 requires us to establish with USCIS that you've worked for at least 1 full year in a managerial or executive capacity with a company outside the United States, which has a relationship, a qualifying relationship with your US employer. So the relationship could be in the form of an affiliate, a branch office, a parent, or a subsidiary. So that is very, very critical. And the requirement also, and there's also a requirement that you actually work outside the US during that 1 year period. There's a lot of people who'll be like, what if I work for my foreign office while I'm still in the US? That is not an option. You have to stay outside the US, work for the foreign office, be on the foreign office's payroll for 1 full year in a managerial and executive capacity, after which the employer in the US can bring you back to the United States on an L1 as an intra-company multinational transfer, where they'll establish you held a managerial or executive role in a foreign office of their organization and are now being moved to the United States to take on a managerial or executive position. And it has to be within a 3-year period when you move to the United States. So essentially what that means is you need to prove that you worked in a managerial or executive capacity for at least 1 full year in the 3 years preceding the filing of the L1 petition by your employer. The maximum period allowed on an L1A is 7 years, and on an L1B is 5 years. Now, just to quickly touch upon the L1B, L1B is a specialized knowledge visa, wherein you could technically work in a specialized knowledge capacity at a foreign office of your US employer. Same requirements as an L1A, except that the role does not have to be managerial or executive. However, you need to have some very specialized knowledge about the company's business operations practices, for which you've received some specialized training from the company that then places you in a position to move to the United States to work on the same specialized knowledge, to apply it at the US office, or to train other employees at the US office in that specialized knowledge. Now, one of the other advantages of an L1 is that if you're married and you have a spouse, then your spouse can apply for an L2 if your L1 is approved, and they're allowed to work in the United States as well. There is no quota, no cap for L1s. Again, they're open-ended, can be applied for any time during the year, but those requirements are written in stone. So thank you for hearing me out on the cap exempt H-1B and L1. Sang, I'll let you move on to the next slide.
Thank you, Shilpa. So moving on from the employer-based strategies to self-sponsored individual strategies, I want to kind of summarize the four big case types we often see most, which is the O1 extraordinary ability, the E1, E2, F1 students options, and the entrepreneur. To start with the O1 extraordinary ability, this is a visa available to an individual who has demonstrated sustained acclaim and contributions in the field. There is a very specific criteria of approvability for this case. I do want to point out this is well covered on our website on our resources, as well as the USCIS website and many other resources and practitioners. The thing I will comment emphasis on this one is that this is USCIS officers are not subject matter experts in art, science, business, or technology. They are administrative officers who are going by a checklist. And that checklist is very specific to what they deem to be a sufficient evidence of extraordinary ability. So for those who are scientists or academics, simply having one or several publications that have been peer-reviewed is not sufficient to meet the criteria. So when you look at the checklist, whether it says awards, publications, press, think about not simply a minimum evidence, but the evidence that demonstrates that you have achieved the top of your field and your peers in that field would recognize you or your contributions. Moving on to the E1, E2, these are, as stated, investor or trade visas available for certain countries that have the requisite trade relationship with the U.S. If you do, then as a national of that country, and if you are able to demonstrate a sufficient U.S. business for that qualification, you can begin working in the U.S. For up to 2 years, renewable indefinitely, and then you can also have work authorization for your spouse, as well as transfer other employees to the U.S. Something that kind of Shilpa was covering with the L1, which may or may not be aware. Regrettably, we're not aware of any resource out there that is a job source for visa nationals. But I will say that our employers that are L1 qualified, that are E1, E2 qualified. So in essence, although your nationality may not necessarily be eligible for a TN or an E3 or an H-1B1, but you are aware of a company that is foreign owned and is of your nationality. That is something you do if you yourself are not the investor or the founder of the E1, E2 enterprise. Moving to the F1, this is probably the largest case type that our clients are utilizing while they attempt to apply for the lottery, this year and future years. Just to cover, CPT is a work authorization for up to 20 hours, a week that is available while you are pursuing coursework in an eligible field. There are academic programs that advertise themselves to be CPT Day 1 eligible. That is something that is currently being utilized by some of our clients. I would caution that Immigration Customs Enforcement is constantly updating and changing their scrutiny. So it would be in your best interest to make sure you do your due diligence when looking at these academic programs to ensure that they are indeed F1 eligible. Simply issuing you an I-20 by itself may not be sufficient. You still have to make sure that it's going to be approved either at an embassy for visa stamping or through a 539 extension application. OPT is for those who have graduated and are able to leverage 1 full year of optional practical training if they were not working full time during their academic years pursuing their degree. And finally, for those degrees that are STEM eligible, which are science, technology, engineering, mathematics, an additional 2 years could be available as long as the employer sponsor is able to provide a sufficient training plan. I will add that it is best to contact your school and ask them directly whether your degree is STEM eligible. We have been aware that there are some MBA programs and business programs and management programs that are still actually STEM eligible based on having sufficient ties to a STEM field. Finally, I'll conclude with the entrepreneurial, which is a relatively new case type. There is a bit of low volume on this right now. We don't quite have. I'm speaking for myself. We don't quite have enough data on this to know full expectations. But this Entrepreneur Pro is a EAD work authorization that is available if you have created a qualified U.S. business that has received sufficient venture capital funding or sufficient government grant funding. The VC funding is 250,000. The government grant funding is 100,000. There are other considerations, but those are the top line requirements. Before I turn to the questions that some of these are coming up, Shilpa, did you have anything you want to add regarding these 4 case types?
I think you've covered it all. I just wanted to briefly touch upon the H-1B one and the E3 and the TN that you brought up during this conversation. Just to clarify, TN is for Canadian nationals, but it's only issued for limited occupations and has very specific qualification requirements. There's a list issued by NAFTA, so you can look it up whether your position would qualify under a TN if you're a Canadian or a Mexican national or passport holder. It is not available to any other countries. The E3 is limited to Australians, and it bears a lot of similarities to the H-1B. The requirements are more or less the same, except that E3 is issued for 2 years and can be extended thereafter. Whereas an H-1B has a hard limit of 6 years and essentially is issued in 3-year increments. So yeah, these were the 2 ones that I wanted to address, but also the H-1B one is for Chilean or Singaporean nationals. It's also an alternate to H-1B. H-1B ones are quite limited and have a very strong, strict non-immigrant intent requirement associated with them. Again, H-1B one also is very similar to an H-1B, but it's limited to Chilean, Singapore, and Singaporean passport holders only. Thanks, Sang. That's all I wanted to add here.
Great, thank you. Moving on now to green cards, and there is a question here I'll address in just a moment because it is related to this. There are 4 main case sets we'll be covering today regarding green card strategies available, with or without a job offer. Extraordinary ability green cards, which are similar to the O1 criteria, but the threshold is even higher for approvability, given that a green card is of much higher value than a temporary O1 visa. Then we'll talk about the EB2 national interest waiver visa. I want to stress that the national interest waiver, or also known as exceptional ability visa, is an EB2. So this is something that is often misunderstood by our clients, that an EB2 NIW is in the EB2 visa bulletin category. So since that is the category that is undergoing a lot of backlogs depending on your country of birth, having an EB2 NIW does not accelerate or move you into a separate fast track. It's the same level of wait time. Then there's a Schedule A, which is both EB2 or EB3, and these are based on very specific positions that have been deemed to be of such labor needs that they can circumvent some of the requirements for other employment-based green cards. And finally, we'll touch briefly on the EB5 investor program. This is well covered in other resources as well as our website, but I'll bring that up as a slide. I do want to bring up this question here from our attendee, Muzami, regarding EB2 and EB1 eligibility, and that your spouse was born in Saudi Arabia, did you yourself were born in India, and whether you wanted to exercise cross-charge. Thank you for bringing this question up, Muzami. Let me take this in parts. We'll talk about EB1, EB2 If you have specific questions about your strategy, we invite you to book a consultation with us or contact our offices. Regarding cross-chargeability, for those who are not aware, cross-charge is a strategy and benefit available for married couples where the green card processing is based on your country of birth, and depending on your country of birth, there is a wait time because the demand in that country far exceeds the supply of green cards available annually. Thus, there is an opportunity with spouses who are from different country of births to leverage the better wait time, in this case, Saudi Arabia, which is under the worldwide category, as opposed to relying on Muzamil's India category. So yes, the answer is yes to all of these, Muzamil. I just invite you to contact us directly, as well as anyone else who has questions like this or similar. So with that, I'm going to move to the EB1. Shilpa, if you would mind kind of walk us through the general highlights of the EB1 category.
Absolutely. But before I get into that, I do want to advise our listeners that we obviously have a time limit to how much we can discuss this today. So I'm going to go over these very quickly. And again, as Sang has repeatedly reminded you, if you need additional details, you're welcome to check out our website to see more information on all of these classifications. And our admin team will be sharing a copy of this presentation or a link to this presentation in the coming days. So you'll be able to go back and revisit everything that we've discussed, plus these slides at a future time, and we'll be able to review it at leisure. So thank you for your patience while we get through this. We will not be able to cover everything in detail, but I'll try and get through as much as I can, as will Sang. So now, as far as an EB1 is concerned, it is an extraordinary ability petition. It is the highest level of green card granted by USCIS for an employment-based preference category, which means that they expect some very high-level evidence when it comes to processing an EB1. The adjudication is done by officers who essentially are not familiar with your area of specialization. So it becomes very critical that a whole lot of information about your national and international accomplishments in your field of endeavor is provided. So national and international accomplishments are usually demonstrated through awards, recognitions by organizations that are closely related to your field of endeavor and are well known. Secondly, you also have to show, you have to show that you have independent corroboration from third parties who are experts in the field, documenting your achievements in the field. Now, there's another category which is called contributions of major significance, which may include authorship of articles which have been published in journals with high impact factors. You may have been invited to conferences as a keynote speaker around the world in your area of endeavor. You may have been published in journals or media articles referencing what you've contributed to your field. You may be a member of organizations where the membership is accorded to you based on your expertise and not just by payment of a fee. So you may be an honorary member, an expert member. So just being a regular entry-level member of a distinguished organization is not considered sufficient if the criteria to get that membership is not based on your expertise. USCIS will also look at, where applicable, of course, on what impact your research has had on in the academic field or the industry as applicable. And they'll also look at your remuneration if it's amongst the top 1 to 5% of the people who occupy that position, because the understanding is that if you're being paid a very high salary, it's primarily due to your expertise in the field, and the company or the organization is really keen on keeping you. So now we can move on to the EB2 NIW. Thank you for that. So the EB2 national interest waiver was the criteria for an EB2 national interest waiver were established by the Administrative Appeals Office through the matter of Danasar back in 2017. What it really means is that you could qualify as an advanced degree professional who has a master's degree in your field of endeavor, or you may have a bachelor's degree plus over 5 years of experience in your field of endeavor, and then you're eligible to apply for an EB2 national interest waiver. But of course, there are two ways you can do it. You can apply it through an employer, or you could do a self petition. If you have an endeavor that's ongoing or a proposed endeavor which has to meet, or rather which has to show that you are serving a very significant national interest of the United States. It cannot be, oh, I have a business, I've created so many jobs. That is not enough. What is it that your work has done for the country other than just creating jobs or contributing to the economy? The understanding is that your work or the endeavor or the business that you have been primarily responsible for founding is actually contributing to an area that is of great interest to the United States. It could be in the science, it could be in the arts, it could be in the field of business, but it has to be one that is in the national interest of the US. Your work also has to be of substantial intrinsic merit, which means it has to have real value to the industry or the field that you are contributing to. Then finally, you also have to establish that there's a reason why the labor certification requirement, which is the PERM process, is being waived for you, because you have uniquely positioned yourself in the industry or in that field, which sort of differentiates what you do from other people who may have a similar background as yourself, who may have a degree in a field like yours, but haven't really made those level of contributions or that level of contribution to that particular field. It's not an easy petition to get approval for, but it's definitely worth pursuing for individuals who believe that they're contributing to the industry that they work in a manner that is over and beyond what anybody else with similar qualifications would be doing. We could move on to the next slide. So now we go on to the Schedule A occupations, where the Department of Labor has categorized certain professions in two categories. One is Group 1 and Group 2. Group 1 is for registered nurses and physical therapists. So anybody who's a registered nurse or a physical therapist in the United States and who has the visa screen approved can apply for a Schedule A green card as long as they have an employment offer. The Department of Labor has already recognized that there's not enough registered nurses or qualified physical therapists in the United States. So they do accept that a labor certification is not needed for these individuals because of the shortage in the industry. However, you need an employment offer, you need the visa screen, and you need to have a license in the state to practice as a registered nurse or a physical therapist where you would be employed. So that is important. Now, that process essentially also is either an EB2 or falls under the EB2 or EB3. The main advantage of that is it doesn't require you to go through the tedious PERM labor certification process to the Department of Labor, which can take up to 1 or 2 years, usually around 2 years. So it does save you that approximately a year and a half in the process, but your position on the line for getting an immigrant visa assigned to you would still depend on the movement of the visa bulletin for your country of birth under EB2 or EB3 based on what the requirements of the position are. Now, I'll briefly touch upon what's called an exceptional ability Group 2 category. Exceptional ability is something USCIS has recently clarified. It can be in the field of sciences or arts, including college and university teachers, but it doesn't include performing arts. You are required to have a job offer, and your employer is required to prove that the work you're doing for that company or the employer actually is extraordinary in nature. But there is some sort of overlap with an EB1A to prove your extraordinary ability, but instead of meeting 3 minimum requirements, your employer is required to prove that you meet at least 2 of the criteria as listed for an EB1A. So instead of meeting 3, you need to meet at least 2 of them. Plus, the employer is tasked with the responsibility of proving why is it that you're an extraordinary ability professional in that field. We could move on to the next slide, please. Thank you.
Thank you, Shilpa. I'll take over on the EB5 information. For a moment, we have some questions, so I want to take a moment here to pause on our presentation and just go to the questions first. So I'm going to go first to Botan Rojo's question. Actually, this is Rodrigo. You asked around the second round lottery. So this is a TBD or we'll see question answer. It all depends on how many H-1Bs that were selected did not end up being used before the June 30th deadline. every H-1B that was selected on April 1st has 90 days to file an H-1B. If those H-1Bs are not filed or used before the deadline, and the number of H-1Bs that have not been utilized by June 30th is significant. We don't know what that number is, but if USCIS deems it to be significant, around July is when we'll expect to probably hear an update regarding another round of lottery. In that case, there will be no action needed. Those who've already registered in March will be automatically considered for subsequent rounds of lotteries. Unfortunately, for those who missed the deadline, you cannot have an opportunity to apply for the new lotteries for this year. You'll have to wait for 2025 and 2026. So thank you for that question. And just as a final data point, what that percentage is speculative. To give you an indication, in the last 2 years, in 2023, there were about almost 500,000 applicants. In 2024, there was almost 800,000. Last year, there was a unusual indication of a high number of people who incorrectly or misrepresented their registrations. So more registrations were open, so allowed for more lottery selection opportunities. But if enough people registered and filed on time, then there will likely not be any new lottery selection. So it's going to be a wait and see moment. To Ali's question regarding her background, this presentation has kind of covered, what we deem to be, fact patterns that are common H-1B alternatives. If during this presentation nothing jumped out, likely there, you fall into the category for most people, which is the H-1B remains the most optimal work visa. And so regrettably, you may just have to wait for next year's lottery or, pursue an F1 or proactively pursue other alternatives. But if there is something in your background, and I say this to all our attendees today, which is more than just an accomplished professional background, a job offer with a legitimate and bona fide employer, that by itself doesn't create any new fact patterns. So we invite you to be the one to look into your background as well as your employer background to see something that is out of the ordinary as far as your professional background. You've achieved certain levels of acclaim or contributions in the field. These are the things that a legal provider would need to discuss to be able to say whether or not there are avenues of approach. So I hope that kind of addressed your question, Ali, as well as others.
Sang, sorry, Sang, I just wanted to add one more thing before you move on to the EB-5. I did want to mention that there are individuals here who may qualify for an EB-2 or EB-3 perm-based green card filing. So you will need to discuss with your employer whether they're willing to sponsor you for a green card without you being on an H-1B or a similar visa prior to moving to the United States. If you're outside the US or if you currently have a visa that's set to expire in the next 1 or 2 years, you could have that discussion with your employer. The perm labor certification process is a very detailed and long process. It can take approximately 3 years from start to finish for individuals who were not born in India or China. This perm labor certification process is not beneficial to individuals who were born in India or China to get any immediate or short-term or near-term benefits, to be very clear. It's a very long process for them, but other individuals who have a different country of birth are welcome to look into that option, discuss it with their employer, and again, reach out to us for any further details on that category. Thank you, Sang, for letting me mention that as well.
Of course. Thank you, Shilpa. So to summarize the EB1, EB2, you are correct. Based on our presentation and when you read about these categories, there is overlap, but the distinction is as follows. EB1 is a higher place employment-based category, so it usually is a shorter or no wait time for a green card effort, but it requires a high level of evidence that you have achieved sufficient acclaim and contributions in the field at large. Essentially, the top of your field, the top 1%. It's not based on just hitting a minimum of publications, awards, salary. It is a overall demonstration that your background is clear and convincing as being the top of your field. EB2 has similar evidence, but not to the degree that EB1 does, mostly because EB2 is on a lower employment-based category. So there will sometimes be a short or just as long a wait time for a green card. And furthermore, the EB2 national interest does require also a bona fide demonstration that that your contributions in the field is towards a national interest, and that you are positioned more than others in the field to pursue that national support and contribute to that national interest. I hope that was helpful. And finally, to Moss's question, with a college counseling qualify under Schedule A Group 2, no. It's arts and science. If that has been successful, we are not aware of that being with any sort of consistency. That has not been the profile for the positions that have been deemed to be Schedule A based on our case experience. So thank you so much for your questions. I appreciate being able to take some time to kind of move through that. I want to very briefly touch upon EB5. This has been a while out for quite a while. There is, again, just plenty of more information on the resources highlighted here. The one thing I want to point out that is often misunderstood about EB5 is that the investment amount must be from a qualified source. Loans, gifts, VC funding are not qualified investment amounts. So the way I term of art is it's got to be out of pocket, which is why this category type is so difficult. It's not simply about crowdsourcing or crowdfunding money. It has to be from qualified funds that have fully vested in the individual applying. So with that, I am going to wrap it up with just a statement for myself and Shilpa. For me, what I want to just be mindful of is that regrettably, if you've attended these webinars and other similar types, a lot of this is well-tread ground. I will just say we didn't cover everything that is available as far as case types, mostly because of time. And frankly, some of these are not appropriate strategies for consistent work authorization and the ability to live, work, and travel. You're going to hear stories about B visa people. You're going to hear stories about J's, M's, other sorts of case types. We won't have any comment on that because those are not work types in the way H, L's, O1s, the ones we covered today are. What we covered today are the optimal work authorization paths, whether they take weeks, months, a year or two, whether or not they are difficult, easy. That's the extent of our presentation today. So we would like you to just kind of look to your background, do your due diligence, do your research, have conversations with your employer, your family, any stakeholder you deem appropriate. Look for resources out there. If in your research you believe you have something that could be of value for your research, just contact us. We're happy to kind of engage you in a conversation. And if your employer, speaking on behalf of your employee staff, please contact as well. We have employer-based, courtesy conversations we can have for those who are employer sponsors. Shilpa, is there anything you'd like to add or conclude before we move into final Q&A?
No, I think we've covered it all to the extent that we could. As Sang pointed out, we cannot get into every single visa category because there are many out there, and but majority of them do not fit in most scenarios. We have to be very specific in determining whether an individual qualifies for a certain category. For example, there's an H-3 training visa. There's an H-2B, which is for non-agricultural workers, but we could get into all of that. But, that doesn't cover a majority of the population that is looking to get options if they're not selected in the H-1B lottery. I do want to end this webinar by saying thank you for joining us, and I wish you all the very best in pursuing visa options or green card options that may actually work in your particular situation. Again, if you need more clarity, we're here to help you. Please reach out to us through the means that the team has shared with you. I did want to take one final question from Eduardo. He said, is it possible to open a franchise and get a visa? Again, Eduardo, it depends on your country of nationality or passport. So if you have a passport that allows for an E2 visa, that's absolutely an option. We have many individuals who apply for a franchise-like arrangement with organizations organizations that exist in the US invest that money in opening the franchise and are able to get an E2. Again, if you need more details, feel free to reach out to us for a consultation, and we'll be happy to guide you as to how that's done and take it from there.
Yeah. I do want to add with the franchise question is that, Eduardo, much like some of these visas where qualified funds is important, E2 investors, whether it's a franchise, whether it's your own business, whether you're buying a business, again, the funds need to be from qualified sources that are already vested with you. Again, this is a situation with the E2 where getting loans or credit card debt, or asking family members or friends for gifts is not qualified funds. That it's not to say you can't use that money towards your business operations, but the E2, E1, other types of immigration case types that permit you starting your own business that is based on qualified investments. Though that investment has to be under very narrow circumstances. As far as your country nationality, you can look under the State Department website or do general searches. You will find plenty of information regarding which countries do or do not permit E1 and E2 entities. So we're getting some last minute questions. We'll go ahead and answer a few more before we wrap up our presentation today. I will say again to Ms. Emile, you've essentially given us your profile. Well, thank you for that. We ask you to contact our offices. We will discuss that more specifically one-on-one. And Eduardo, E2 Mexico, Shilpa, I can't recall. Is that qualified?
Absolutely a country. Mexico does qualify for an E2, so by all means, an E2 is an option for you should you find the right franchise and the right amount of investment. Again, please do your due diligence before investing in any business in the United States, because it's your hard-earned money. And as Sang mentioned, the embassy or USCIS, depending on where we apply, will closely look at the source of funds. And if you're taking money from your parents or sisters or brothers or family members or friends, they'll also go and look at their earnings to ensure that they were able to obtain that money legally as well. So you have to establish a chain of where the funds originated and whether those funds were obtained legally. Again, please contact our office if you need additional information. And
this last one here before we close, and thank you, Shilpa. Yeah. The answer is no. A 539 pending application. Oh, wait a minute. Sorry. So this is for OPT, for F1 OPTs. You have to ask your school. Your school will be the final authority on all F1 status questions. There may be nuances to your background we're not completely aware of, but in some circumstances, yes, a timely filed F1 extension of your work status from OPT to STEM can be eligible for work authorization while the extension is pending. But you need to contact your school directly. They will give you the definitive answer on that based on your specifics. Thank you so much.
Just that question, I wanted to add that it depends on the kind of change of status you're applying to. If you're applying for a change of status to, let's say, B2 or another visa category that you may qualify for, as long as you file the change of status before your OPT grace period ends, yes, you're allowed to remain in the United States while the change of status is pending. Of course, please keep in mind what Sang mentioned too. Please coordinate with your school so that you know what exactly your grace period is and when does it specifically end, because those are very critical dates or days, as they say. So please only apply for a change of status if you're still within your grace period and are legally present in the United States. Otherwise, USCIS will not approve the change of status, and all the time that you spend in the United States will then be counted as unlawful presence. Again, thank you for this opportunity to discuss these options with you. Sang and I hope we've been able to answer a majority of your questions and have been able to provide you with some alternatives which may be helpful to you.
Thank you so much. Take care.
Bye-bye now.